This matter comes before the court today on Cure Insurance's motion for a entry of a default against Ms. Canosa and Mr. Kimbrell. And I would ask counsel for Cure if you, or would you counsel for the insurance company, would you place your appearance on the record?
Good morning, Your Honor. Charles Torno,
Bluetooth connected.
P73998 on behalf of Cure.
Very good. Thank you, Mr. Tornow. And I do see, it looks like either Mr. Kimbrell or perhaps Ms. Canosa or both are connected here on Zoom. Who do we have present for defendants? And you're going to have to unmute Kimbrell, Canosa connection there. You're going to have to hit that red microphone so I can hear you.
And start. There we go, I think.
Yes, I now can hear you. Who do I have? Is it Mr. Kimbrell?
Yes, this is Mr. Kimbrell and my grandmother, Diane Canosa.
All right. Would you state and spell your full name for the record, please, Mr. Kimbrell?
Yes. Andrew Kimbrell, Kimbrell.
All right. Thank you, sir. Mr. Kimbrell, have you retained counsel to represent you in this case by chance?
No, I haven't.
Okay. And do you understand the kind of the mechanics of this case in that, Citizens United has served you with papers that say, hey, we don't cover you under our policy and further, are going to cancel the policy. I think that named maybe Miss Canosa, your grandma, as the insured, retroactively because she didn't disclose that you were living with them at the time of the application. Do you kind of understand what's happening?
Yeah, I understand what's happening, and she is aware of it as well. However, yeah, it's more. I believe it's more of a misunderstanding than anything. My grandmother would like to speak, or did you still have more to say?
No, that's okay. I'll hear from Miss Canosa as well. Miss Canosa, would you state and spell your full name for the record, please?
Diana Shirley Canosa.
Could you spell that for me, please, ma'am?
Kanoz as in zebra, A.
Thank you, ma'am. And Ms. Canosa, do you understand the nature of the case that's been filed against you by your former insurer, at least Citizens United Reciprocal Exchange?
Yes.
Okay. And have you retained counsel to represent you in the case by chance?
No, I haven't, because I figured that I would take care of it myself.
Okay, well, that's a very hard thing to do in a complicated insurance case in court like this. Not impossible, but pretty darn hard to do. And I mean, you're in a position now because you haven't responded to the insurance company where they're asking me to say, Judge, everything that we said in the complaint is true because we don't have any answers, and that's exactly what the law does. Is that if you don't answer within the requisite amount of time.
I did answer.
Oh,
Sure.
you filed an answer in the complaint?
Yeah, we've been in correspondence with them pretty much up to just until the last 1 or 2 months. We had been communicating with them regularly.
It was on the phone.
Yeah.
Yes.
Well,
It was on the phone, and they documented it. They had a recording of it all.
sure. No, let me clarify for you though. When I say answer in court, you're exactly right. Answer in everyday life means I answered the phone or I responded to the email. And answer in court means I filed a paper that says, I deny their allegation number 1 is true. I deny their allegation number 2 is true. And then it's signed by the party, that's filing the document at the end of it. It's a very specific term, as all terms are, with legal filings and filings in court. And that's exactly the reason why I'd say, if you want to mount a credible defense to what the insurance company is saying here, the most uh, effective way, the only effective way, in my estimation, would be to retain an attorney. You could either hire an attorney at your own cost or possibly access an attorney through a no charge. If you qualified for legal aid, you could try to get a civil attorney to represent you through legal aid, and they might weigh in on your behalf and agree to represent you on this matter.
At the time, I thought when they called me, there was a number of calls to the claims department and to different people that I talked to at the insurance company, and they told me that it was on a recording. They told me that everything I say was documented. So I just never thought I had to put it in writing. I mean, I just figured they have it all my messages and talk to a live person, but it
We
was
didn't know we were being sued up until the very last.
yeah, we didn't know. And then what they did was apparently I didn't have any insurance. Not knowing I didn't have any insurance, I I still paid them money for December, January, and February. They still charged me, and I paid my insurance company. But I didn't know I didn't have any insurance. I paid them for nothing, and they said they returned my money to me, but they never did.
You haven't seen that check yet. Well, all of those would be very valid things that you could raise via an attorney. But the way you're going about it, though the insurance company does record, and you're correct, all that information would be in their claims file. It has exactly zero visibility in the legal file that's in front of me, unless the insurance company puts it in there. And I can guarantee you, if it's not against if it's against the entrance of what they're trying to say, it won't make its way in front of me. So you really do need to secure uh, legal representation if you want to defend this. Mr. Turno, anything to add to that?
No, just that we served the complaint personally to each of them. And that went through on May 20th last year. Their defaults were served July 3rd last year. This is the first time, at least, that our office has heard from them that they showed up today.
Yeah, I understand. Knowing commonly, of course,
Yeah.
they're talking to the insurance company. They don't recognize you. You're not the insurance agent or the people they've dealt with in the past. So, right, that probably explains that. So, I think, the other tricky, sticky part of this here is it might seem like Ms. Canosa and Mr. Kimbrell, you could be represented by the same lawyer. However, that also might not be true, and that your interests might diverge at some point, and you might have to have separate attorneys. However, I'd recommend trying to get Ms. Canosa, since you're the alleged policyholder, I guess it would make most sense for you to be the first one to request an attorney, for example, if you're going to go to legal aid. And then, initially the person could evaluate whether they can represent the both of you or not. And then I would, if failing at legal aid, I guess I would reach out to an attorney who does civil insurance work, who you could hire. That would be quite expensive. So,
Why is that? Could that be a conflict of interest to have the same attorney?
yeah, it could be because, the basic allegation here is that the reason the policy was canceled was because Mr. Kimbrell lived with you uh, at the time of your application for insurance, and that application didn't say, "Oh, by the way, my grandson lives with me at the house," and they're saying that's the kind of misrepresentation that allows them to cancel
Yeah,
the policy.
yeah,
So,
which wasn't true, which at the time was not true.
yeah, no, and that's exactly why you do need to have an attorney to represent you in this matter. However, we are at the point, when they're requesting a default judgment, this is the proverbial point of in a case where you need to fish or cut bait, as they say. So, what I'm going to do, Ms. Canosa, Mr. Kimbrell, is I will reset this for another date, a month in the future, during that time, which I expect you to go and make some efforts to retain an attorney. If you're successful, obviously the attorney will appear with you at the next hearing. If not, then do save the documentation of your efforts to get an attorney so I can evaluate that and determine where to go next time. Because if I, declare this default judgment in the favor of the insurance company, you have lost the case in court before you even had a chance to get out of the blocks. So I am going to, at this time, grant a 30-day. I'll reset this in 30 days. So I'll adjourn the hearing on the default for 30 days for the purpose of you obtaining an attorney.
What happens?
What are they seeking in this judgment?
Well, if they win, and I can't, give you a full range of legal advice, but the certainty is that insurance policy then would be canceled out. What they're asking for is called from the date you signed it, from the date you tried to get insurance and made that false representation, there would be no insurance. In a legal sense, that means that you would be uninsured at the time of the accident. And I think, Mr. Kimbrell, you may have been the involved driver here. That would mean you were uninsured, and it would trigger, that Michigan law talks about what happens to uninsured drivers. But part of it is you could be, of course, personally liable for any amounts found against you.
Would that have pertain to anything with criminal court, or would it stay in civil court?
This is purely in civil court. There are no criminal charges attached to this at this time. There are, of course, you do have to have insurance and yada, 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 but there's that's not implicated here. This is all about money.
Everything's about money.
Well, that is the nature of capitalist society. And the other thing is, for both of your perspectives, well, what could be the worst? Well, you get saddled with a full range of damages and medical bills in a case like this, which could easily, of course, exceeded, $250,000, $500,000. And that's a judgment against you that basically sits there financially for the rest of your life. So
Sir, I'm sorry. There was no medical bills that we're aware. We didn't file any medical bills.
No, it could be the other driver in the case that was injured suing you. So that's the unknown piece here. Mr. Turnout, do you want to add something to that?
Yeah.
I had a quick question, Your Honor. And what would my legal grounds be for countersuing or something like that? Because I did get injured. I had my hip broken in 2 places.
I'm in no position to advise you on that. You could have, if the insurance was in effect and covered you, potentially you'd have a claim against the insurance company for any medical expenses you incurred. But you'd want to. The key for you there, Mr. Kimbrell, is you might have enough grounds to go to a private attorney, and that might be a case that they would handle for you to recover those medical bills, because there are provisions that they can get their attorney fees from the insurance company. So I'd advise you to consult with a private, no-fault auto attorney on the matter.
And
I definitely will.
Can I ask a couple questions here?
Yep, go ahead, Ms. Canosa.
They got on my insurance thing that I was in a number of accidents. I haven't been in an accident in 30 or almost 30 years.
Yeah, I don't know. I can't speak to that, Ms. Canosa. I have no idea, where they get the information or how that impacts the case.
And that's one thing. And then I never received. They charged me. I paid my bill every month, and they never returned me a check, knowing I'm driving with no insurance, not knowing I don't have any insurance, and they took my money and never reimbursed me.
I got it. And I do think somewhere in there it says they at least promised to reimburse you, although I don't think it says as much as they delivered the check yet. So that might still be in the process. Any insight on that, Mr. Turnow?
Kira's been doing a thing where they hold the checks just for legal expenses. It should go soon. I will reach out to the adjuster and make sure that find out what's happened there.
I
And the
would
other
say
thing
if
is,
they, yeah, want to sustain their default against the legal challenge, the least they could do is return the premium, as they say they're going to do when they do this. So
the
I
other
already
thing
looked,
is,
and you can transmit to Mr. Tarnow to Cure that I already looked somewhat askance based on some prior cases, those practices, and I'll look further askance at them if they are not doing what they say they're going to do.
the other thing is, it takes a long time to go through legal aid, and because I have went for other problems.
He said at least if you show him that we've been trying to get legal aid,
Yeah.
Oh,
we can
Yeah, if you have an
proceed.
attorney in a month, in 30 days, or right, are approved for an attorney and we're making some progress towards an attorney, then I've got reason to give you additional time. I just need to see that you're making some effort on
okay.
your end, and that, like I say, Ms. Canosa, you really do need an attorney to do this because of the complexity of the legal proceeding against you.
Yeah.
Okay, I see. All right, well, I will try to get a legal attorney because we're on Social Security and have no way to pay a lawyer.
We'll
That
definitely.
should, the good news is, that's a hard thing to live day to day, but the good news is that ought to qualify you hopefully in the door, at least financially, at legal aid.
Yeah, yeah,
All right,
okay.
very
Well,
good. Thank you. I'll see y'all in 30 days and see where we stand. And like I say, it'd be very helpful, any way you can to get an attorney. And if legal aid says we think it, somehow, might be a paying case, then try a regular no fault attorney. I'm not an expert in this and I can't really give legal advice. They might see something that I don't see here. So,
Yeah, we will definitely try to figure out what our options are.
will you send something in the mail that when it's
Yep.
gonna be?
the next thing you'll get from me will be a notice of the new hearing date, which will be about a month from today, on a Friday, just like this hearing was. And I'm glad you all are able to navigate Zoom. Not everyone is, so
I was able to.
Yeah,
Luckily,
very good.
we
You're the tech consultant. I got it, Mr. Kimbrell.
yeah, because
right.
I am technology dumb.
Well, you're in the same situation I am, Ms. Canosa, so that's all right. All right. Well, I greatly appreciate you folks making the effort to appear, and it is at the 11th hour, so we got to get going on this thing. But nonetheless, otherwise, it's very routine in a case like this to simply grant the insurance company's motion, and then, as I said earlier, you'd find yourself in a, basically out of
Well,
luck
I know
legal
that's
situation.
I know that's from now on because I figured they're recording everything. They told me in the beginning of the recording, so I figure
Yeah,
they
I'm
got
on the
it all.
record already. No, in a court proceeding is always an entirely different animal. So when that process server shows up or you get a letter or a notice from the court, the best thing to do is to turn to an attorney and say, hey, what should I be doing next? So, and yeah, unfortunately, not the kind of thing that you can do with a phone call generally.
I see. All right. Oh, all right. Well, thank you so much.
Yes, thank you very much, Your Honor.
Very good. I wish best of luck to you all, and I'll see you all in a month.
All right. All right. Thank you.
This is the people of the state of Michigan versus Jamal Glenn, case number 24-04464-FH.
And this matter comes before the court today on defendant Mr. Glenn's request for an order to show cause, imposing a fine for contempt of court against the home flat apartment for a failure to provide certain information regarding the electronic records of the company. I'd invite counsel to put your appearances on the record.
Tiffany Burks on behalf of the people.
Christina Nunzio on behalf of defendant Jamal Glenn.
All right, thank you, Ms. Nunzio. Ms. Nunzio, this is your motion, and as I read through this, I think of it, of course, what you're really trying to do here is you're trying to get a piece of what I would describe as more civil discovery, akin to what I would see in a civil case, in the context of trying to supply some new evidence in Mr. Glenn's case. And then I thought, well, if an attorney was trying to go about getting these records or determining what exists in a civil context, what would you have to do? And the reality is you'd have to do depositions. You'd have to do them of the home flats people and get them on the record as to what their IT practices and retention policy was. You'd have to get the new IT company the same, and a representative of the old IDT company the same. And also, at some point, you'd have to take the deposition of the Wyoming police officer and determine, what information they had or didn't have that impacted this case, because I'm still struggling a bit to see, what information may come forth that would change Mr. Glenn's outcome in any substantive way. And I don't see it done here, and I just frankly don't think that this, the subpoenas and orders to show cause that I've permitted thus far are the right avenue. What are your thoughts?
Thank you, Your Honor. One, I just wanted to place on the record that Home Flats West was served personally by Damien D. Nunzio last Friday to appear. So it is clear that they are ignoring the subpoena. Second, I understand the court's analysis of potential this should be done in civil court. However, I'm kind of, handcuffed because I'm post-trial. I'm trying to essentially figure out what went wrong. And the main issue for defense is that these logs that go to Mr. Glenn's home should have been collected either by the police department or previous counsel. I do think that if there was a record of someone else gaining entry to Mr. Glenn's apartment that is not maintenance, it would have a profound impact on the case, such as it would be impeachment evidence against the complaining witness, who stated that she did not have a key and did not get into the apartment building or Mr. Glenn's apartment via a key.
Well, let
There,
me just pause you. Let's say, give you the benefit of the doubt that all is true, and she does have a key. Well, presumably, this is Mr. Glenn's former girlfriend. She's carrying his baby per her account during the trial. The most likely source of the key is Mr. Glenn himself. How does that help him a whole lot?
well, Your Honor, there's records of when these keys are made, and Mr. Glenn never requested an additional key. So how an additional key got out there is um, it's left up in the ether because we just don't know how this happened. There's a process to get a new key. You got to pay $100. You got to sign off for it. Mr. Glenn never signed off for an additional key. So there's someone got a key to this place without Mr. Glenn's knowledge or consent. And it goes to the heart of the complaining witness's potential bias and motive to essentially elaborate and, maybe hyperbolize what happened between her and Mr. Glenn because she was a federal employee, and certainly breaking and entering into someone else's home would cause a lot of issues for her criminally and for her job. So it is a huge
Well, I don't
issue
think
when
you're
it
going to get to breaking if she has a key, unless she stole the key, again, who she steal it from? Well, obviously, the only one that probably has the key at all times is going to be Mr. Glenn himself. And, they're having this dating relationship. She certainly, I stretch this thing out and think in my head, what would I say? I'd say, yeah, I took the key, but I thought it was okay to take it because we were, sleeping together. I'm pregnant with this kid. Why wouldn't I have a key and have access? And, I also just kind of, if I back off and look at this thing from 30,000 feet, I think, okay, you know, I get it. Mr. Glenn didn't want her to be able to get into that apartment without his permission. Uh, maybe because he was worried about security and being robbed. I don't believe that a bit. I think he wanted to do what he wanted to do inside that apartment, including, you know, possibly taking up with other women and didn't want her to bother him. And he's been convicted now of this, you know, vast overreaction at best where he violently attacks this pregnant lady when she's, you know, by her account coming in to tell him she's pregnant. Now, you know, I'm sure Mr. Glenn's account is probably something more like she was conducting, you know, some sort of surveillance operation on him and wanted to catch him with this other woman and, you know, get photographic evidence for sure that he was a bad guy. But, yeah, she already got that. He attacked her and there's blood all over the walls and the jury convicted him. So, you know, I got to say, I've been holding off on sentencing Mr. Glenn. Mr. Glenn's entire story here is not one of, gee, I did something wrong or, you know, I'm remorseful that I did something here. It's trying to prove up this, you know, pretty attenuated theory I have that the police, the complaining witness, someone did something that wronged Mr. Glenn in the whole deal, and thus the whole outcome here was wrong. I mean, it seems to me to be one of evasion of responsibility, and it's frankly causing me to reconsider the fact that I was going to give this guy a year in jail, you know, on guidelines that say I probably should be sending him back to prison. So, you know, just from a strategic point, my counseling to you would be, you know, talk to your client. You know, I'm not going to find the home flats because I've heard from the home flats before, and it seems like, you know, you know, we'd like to think of these apartments as maybe they're sophisticated IT networks and things like that. The reality is they're small businesses and they change managers every 2 years, and the guy probably has no idea what happened before or even very much about how that IT system works. Like I say, there would be a way to go about it. I'll give him additional time, you know, to produce those records and come out. But I guess I'm just thinking, you know, even in a best case scenario, if that record, you know, spit out and it said, you know, more or less the most it can say that that was accessed with the card other than maintenances. And of course, you know, who was holding the card and stuff like that at the time, we don't know. Is it going to do Mr. Glenn that much good? As opposed to the effect that it's having now of irritating me because I'm not able to sentence him. And even on a bigger, you know, I view it as Mr. Glenn's you know, a continued effort to avoid the consequences, you know, of, you know, what he's done here. I mean, after all, this guy did 9 years in federal prison prior. It's not like he's a saint who, you know, this came out of the blue and hit him. He knows darn well what the stakes are and what he's facing. So, given all that advice, I'll set this one. You know, I'll give it. Do I have a sentencing date for him?
Yes, Your Honor. You have it set for April 2nd currently.
Yeah. Well, I mean, I'll give.
Your Honor, may I just add
Yeah,
to the
yeah. Go ahead,
record?
Ms. Brooks.
Okay, and because I know Ms. Nunzio wasn't in trial, although probably does have a trial transcript at this point. I don't believe that whether or not this victim had access via a card of her own, I don't actually think that having a card of her own is going to help the defendant in any way. So if this comes out where she actually had an access card of her own,
Where
then that
she
kind of,
stole the card, Ms. Brooks. What
or
if
she
she
stole it, that kind of,
from? I mean, she's got to get it from Mr. Glenn, I suppose. But they're having an intimate relationship. She would have access to him, I suppose. You know, if I were in her shoes, I would say, well, of course. You know, Mr. Glenn said I should have a card, and I just took the one that was sitting on the counter, or he told me it was okay to take it, or I reasonably assumed it was okay to take it because we were sleeping together, and he said I should come over anytime, or something like that. You know, I mean, I can extrapolate about 10,000 scenarios where she gets a card, given the nature of the relationship. It's not like these two only saw each other one night at a bar or something. They were in a romantic, extended relationship. So, Yeah, right. I agree with you, Ms. Bergson, that even in the worst case, and I think that then, okay, so she had this tale, then she would have perjured herself, obviously, during the trial because she would have said, well, the maintenance guy, I think her story was a neighbor let her in down at the first access point, and then the maintenance guy at the second access point, and um, right, she would have perjured herself, but by doing that, but again. Um,
But that
Y-
helped Mr. Glenn's self-defense claim in this case, or his intent to do a self-defense claim. If she had a key, that would negate that whole thing.
I agree, which is why I've been tracking this down.
Yeah,
Um, I will, Your Honor, obviously everyone has different opinions about what this evidence could or could not be. I guess I just ask this of the court. I don't think Home Flats is going to comply at this point. I've certainly done my due diligence to try and get this information.
well, I
What I
mean,
would like,
short of you do have all those civil discovery things, and had we, if I had 4 deposition transcripts sitting in front of me and I was digging through that, like I'm going to do I had a civil case up this morning where they're trying to track down spreadsheets, and of course they've taken depositions of everyone and probably spent 100 grand, finding, what that might or might not be, important evidence in the case, and that's just the way civil cases go. But I just, short of that, um, I don't know any other way that, you're trying to do it kind of here in a, fastest, most efficient manner, but, it also has some limitations to it. So, yeah, I think even if I order Home Flats to come in here next week and provide it so we can have it prior to sentencing, I don't think they're going to comply either. And I don't think they're not complying because Home Flats is, um, giving the middle finger to the court or trying to hide something here. I think rather Home Flats is just at a loggerheads where they're like, gosh, we've dug up what we can. We don't know what to do, and might there be something more out there? Sure. But the process to determine what it is in terms of a legally actionable part of the case would be very expensive. So, and the big unknown is at the end of the day, would you spend all that money, get to that place, as often happens in civil litigation, and you say, well, it's a little bit helpful, but it's not the, exonerating piece of evidence you're hoping for. It's something less than that. And I think there's every chance that that would be the case, even playing this out in my head. So, what's your suggestion, Miss Nunzio?
my only, I guess, request would be, and I know, I know I'm asking a lot. I'm asking the court to bump sentencing one more week. And assuming that I can, well, I guess this is a question for Wendy. Wendy, when is the next motion hearing date?
Yeah, I've got my spring break in here, which is going to impact that.
Yeah, if the court could just allow me to file a motion for new trial before sentencing, that's
That
all
will
I
kind of
ask.
close the loop on this thing.
Yes, Your Honor. And at least, my client, obviously, he's gung ho that this gets filed before sentencing. Um, so if the court would grant me just a little leeway so I can get that done so that,
Given the amount of leeway I've granted, and to Mr. Glenn's credit, he appears to be doing fine on bond. He's not out there proving, that he's a career criminal. So that's a good thing. Yeah, when's our next one after spring break, Wendy?
April 17th.
Yeah, let's take that as this. Let's move the sentencing date to April 17th. Get that motion filed.
Oh, Judge, no, that's the motion date.
Oh, the motion date. Okay.
So
All
our
right.
next sentencing date would be the 30th, but we have a lot of them.
Mhm.
well, I mean, if the court wanted to do sentencing after the motion hearing, I'd be fine with that on the 17th. Ms. Burks, do you have any position on that?
I guess it's up to the court because motions
Yeah,
I know are
it'll
normally
be
done
by
on
Zoom
Zoom.
and he's going
Right.
to jail. That's always a sticky wicket.
Oh,
So he probably should be in for a sentencing, so.
I could do sentencing. Let's see here. Let me look.
what about the 23rd, Wendy? That's the Thursday after the 17th.
That is a civil week and we normally don't schedule them, but I could just schedule this one.
Yeah, let's
Okay.
do this one and get it in.
And it would be at 1.
Okay, 1 p.m. on the 23rd for sentencing.
Actually, Wendy, why don't we push it a little earlier? Because otherwise that'll be right in the middle of task.
You don't have task that week.
Oh, I don't have,
It's-
that's a off week.
It's a civil
Okay.
week.
All
Yeah.
right. Okay.
Your
Wendy,
Honor,
you
Wendy,
want to
can we
please?
just agree to no more adjournments of sentencing? This
No, this
victim
will
in
be
Yeah,
this
the
that'll be
case
the
last.
final
is,
sentencing date. We have been waiting just I agree, a ridiculous amount of time to do this. And you know, I feel like, you know, we've kind of chased this particular you know, possibility about as far as we can within the limitations of what we're doing. Because like I say, you got those civil rules that, you know, one of the things that occurs to me in criminal cases is, you know, you've got you know, the court rules say if it's not covered in the criminal rules, then you defer to the civil rules, which means you got all, if with the court's permission, you can proceed down all those roads of discovery and depositions and stuff. And it's rarely done. And I think the reason it's rarely done is because of the time and cost requirements of doing it. And I mean, I think that's what we're bumping up against here. And I totally understand that. I don't know that it'd be worth spending you know, 50 to 100 grand in civil depositions and court recorders and all that stuff, you know, for the likely evidence you could present to the court at the end of the day. With a note being a civil lawyer in $1 million case will do that in the snap of a finger. See, I would take those 4 depositions given that same situation. So, but you know, Mr. Glantz doesn't have the luxury of a litigation budget. So,
That is true. And Your Honor, just for your edification, in criminal cases, we are not allowed to conduct depositions. So that's not something I could even have done.
no, I think though, with the permission of the court, you can invoke and get, you know, most of the benefits of the civil discovery rules in a criminal case. Right. There's no discovery, of course, in a criminal case under the norm rules. It's just the exchange of the evidence. But I think in a case like this where you're trying to get something tangential, and I mean, the only reference point would be a case like Sure, for example, where, you know, the stops are pulled out and you're going to spend millions of dollars to defend a case. Well, in those cases, you probably do depose like expert witnesses and stuff with the permission of the court, you know, to freeze their testimony just like you would in a civil case. So.
Your Honor, so what is the court's ruling today? And then
I
I need
will
just some
adjourn sentencing
clarification
to
on
the
the
new.
motion.
Yeah, no, that's a great point. And the motion is in order to show cause. I will order Han Flats to produce anything they have or pay a $100 fine no later than a week from today. I think they've already given you some stuff, right, Miss Nunzio? They just haven't been able to, for whatever reason, broke out.
Well, Your Honor, they've given me a whole lot of nothing.
Yeah,
So
well, and that's unfortunately the norm, you know, and what you're trying to chase down here, you know, right? They're going to give you printouts and say, oh, these are our email records and stuff like that. But I would expect if we deposed them, you know, the people that or the guy that I heard from the one time here, he's going to say something along the lines of, that's what I got, you know, and
yeah.
you know, so in a lot of extents that my experience with witnesses like that is that's true. You know, they don't have the guy's not an IT expert, you know, he's a guy that collects rent, you know, before the 30th of the month every day. That's his primary function in life. So it is what it is, as they say.
Okay, so I will submit an order of production
Yeah, or
within
pay
the
the
next week.
$100 fine, right, if they fail to produce anything, you know, if they don't show up, well, that'll be the consequence for them. That might get their attention and, you know, they might go through those records once more and reproduce what they already have. I don't think you're gonna get anything more. and then we'll set the sentencing date, and you can file the new trial motion based on what you have thus far.
Okay, Wendy, can I send you a notice of hearing to preserve that April 17th date and time?
Yes, and I'll go ahead and get it scheduled.
Thank you.
You're welcome.